Are you new to business and had no idea about obligations and contracts? Well, you are in the right place, for we are going to discuss the general principles and considerations of obligation and contracts. First, let us define obligation. Obligation is a duty to do or not to do something. In its legal sense, obligation is a civil law concept. An obligation can be created voluntarily, such as obligation arising from a contract, quasi-contract, and unilateral promise. How about contracts? Contracts is an agreement between private parties creating mutual obligations enforceable by law. The basic elements required for the agreement to be a legally enforceable contract are mutual assent expressed by a valid offer and acceptance, adequate consideration, capacity, and legality. There are different kinds of obligations. From the viewpoint of sanction, there are three kinds of obligations: the civil obligation, natural obligation, and moral obligation. Civil obligation is one which binds in law and which may be enforced in a court of justice. Natural obligation is an obligation that has no legal basis and hence does not give a right of action to enforce its performance. It is based on equity, morality, and natural law and should be voluntary. Moral obligation is an obligation arising out of considerations of right and wrong. From the viewpoint of subject matter, there are two kinds of obligation: real obligation and personal obligation. Real obligation means legal obligation that is connected with real property. It is a duty that corresponds to a real right. In other words, real obligation of a person refers to those duties that a person must perform in return for the right that she exercises. An example of real obligation is mortgage. Personal obligation is the obligation to do or not to do. An example of this is a duty to paint a house. From the affirmativeness and negativeness of the obligation, there are two kinds of obligation, which is the positive or affirmative obligation and negative obligation. Positive obligations are, broadly speaking, obligations to do something to ensure respect and protection of human rights. Negative obligations refers to a duty not to act, that is to refrain from action that would hinder human rights. From the viewpoint of persons obliged, there are two kinds of obligations. These are called the unilateral and bilateral obligations. Unilateral obligations are obligations undertaken voluntarily, when a person promises in definite terms to do something to benefit or favor another, and may therefore be under a legal obligation to keep their promise. An example would be a promise to donate a sum of money to a charity. Bilateral obligation is where both parties are bound.
Basically, it explains that obligations arising from law are not to be presumed, meaning dili ka mo assume. It must be clearly stated or expressed in the obligation that it was provided by the law, making the obligor subjected to follow. Dapat na ay clear provision, dili speculation. Dapat malinaw na nakana na person is covered by the law. A very common example is the obligation to pay taxes. Validity of any contract expresses the principle of autonomy of will. It has own provision, mandate, and guidelines that should be observed. However, the autonomy of will only be on its power of rule if it is inconsistent with other statute, most especially the Constitution. If found to be otherwise, the autonomy of will of the contract will be ruled out. A quasi-contract is a juridical relation which arises from a lawful, voluntary, and unilateral act or acts executed by somebody from the benefit of another and for which the former must be indemnified to the end that no one shall be enriched or benefit at the expense of another. There are two kinds of quasi-contract. The first one is negotiorum gestio, a juridical relation which takes place when somebody take charge of the agency or management or property of another without any power from the latter. The second one is solutio indebiti, a juridical relation which takes place when somebody received something from another without any right to demand for it. This provision refers to civil obligation arising from crimes. Under the law, every person criminally liable for a felony is also civilly liable. The civil liability arising out of the commission of crimes includes 1. Restoration, 2. Reparation of damage caused, and 3. Indemnification of consequential damages.